A judge in Fulton County, Georgia, struck down the state's strict 6-week abortion ban yesterday. That ruling now allows the procedure to resume and makes it legal in Georgia up to 22 weeks of pregnancy. The ban originally signed into law by Republican Governor Brian Kemp back in 2019. The Superior Court judge explained in his ruling that liberty in Georgia includes the power for a woman to control her own body. But he added the power is not unlimited, stating, quote, "When a fetus growing inside a woman reaches viability, when society can assume care and responsibility for that separate life, then and only then may society intervene." Joining us now, former litigator and MSNBC legal correspondent Lisa Rubin. Lisa, good morning. Great to see you. A lot of people had been watching this case very, very closely to see where it would land. What was the decision ultimately by the judge here?
Decision ultimately by the judge is that the prohibition on abortion beyond that 6-week mark when a fetal heartbeat can be detected is no longer good law. And he says that that's rooted in Georgia's own constitution, that there's a recognition of a right to liberty, that liberty includes a liberty of privacy, and that Georgia's own law recognizes that that liberty of privacy is broader than the federal constitutional right. And on that basis, he said, as you just noted, that although the state has a compelling interest in promoting fetal life, where you're balancing that against a woman's liberty of privacy to control her own body, the state's interest is not so compelling as to overcome the woman's right to control her body until the fetus is viable outside that body.
So this is that debate we've heard a lot since Dobbs, which is the heartbeat, 6 weeks, versus viability at, say, 22 weeks or whenever you set that standard. So as of now, women in Georgia up to 22 weeks, because of this ruling yesterday, can get an abortion. But I assume this will be appealed again, perhaps all the way up to the Supreme Court.
Yeah, and I think there are some people who will be afraid to perform abortion in the intervening time period, because this isn't just a ban on abortion, Willie. This is a criminal prohibition on abortion. And as Judge McBurney, who is the Fulton County Superior Court judge who issued this decision, notes, the woman herself could be prosecuted because of the way that the statute is worded. That's a particularly pernicious place to be, and he recognizes that all throughout his decision. This is, I want to be really clear with you and our viewers, this is almost a radical decision in its recognition of the right of women to control their body, and more importantly, to sort of prevent against a sort of involuntary servitude or forced labor. There's a recognition here that women are not, as he says, collectively owned community property, that they cannot be forced to carry a fetus before viability any more than you or I could be forced to give up a kidney. That's a fairly radical conception of the right to abortion, and made a lot of women I know think, oh my God, this is the end of judicial gaslighting. There is someone here who sees us.
At the end of the idea of women being collective property being considered radical is extraordinary.
Yes.
Lisa, so do we think that this ruling could serve as a template for other states that have had restrictive abortion bans put in place?
Well, you know, I think it depends on what that state's law is constitutionally, right? Because each state is interpreting its own constitution. Some of the other states that have recognized a fundamental right to abortion in their state's constitution don't do so from a liberty perspective. They do so, for example, on equal protection grounds. Here, though, Judge McBurney is saying Georgia has a long history of recognizing a broad right to privacy, and that's why he roots it there. On the other hand, I think there are some pieces of this opinion that could be very helpful for other judges to latch onto. In particular, he really disavows textualism and originalism. Those are the constitutional interpretive methods of the day. And he says the problem with looking for the original public meaning of constitutional text is that it necessarily excludes half the population. Women who had very limited rights in the 1860s, for example, when some of these provisions were put into place, and black women who had no rights at all. And that's explicit in this opinion.
Caddy?
So, Lisa, women in Georgia have a reprieve for the moment, and women, I suppose, in other states, were there to be similar lawsuits, might have similar reprieves for the moment until those reprieves themselves are challenged by higher courts. Presumably, the only way that this gets completely resolved and that there is a standard that allows women to have access to abortion up to 22 weeks of viability would be for some decision to be made by Congress or a reversal at the Supreme Court.
I think, Caddy, that's true, although theoretically the final word here should really be Georgia's Supreme Court interpreting its own constitution. What makes this decision really important is that again, if folks like former President Trump are saying abortion is left up to states, this is a state court judge interpreting his own constitution. Yes, it will likely be appealed all the way up to Georgia's Supreme Court, but the text here that matters is Georgia's constitution, not the federal constitution. And while Congress could certainly make abortion legal all across the nation, for Georgia's women right now, what really matters is their constitution. Judge
McBurney writing in this opinion, a mere 6 weeks is a point at which many, if not most women, are completely unaware or at best unsure if they are pregnant. He believes that's too soon, putting it at 22 for now, 22 weeks. MSNBC legal correspondent Lisa Rubin. Lisa, thanks so much. Appreciate it.